Good. Well, welcome. Thank you for joining us here today. We're talking about the new CFPB integrated mortgage disclosure forms. And I understand that our audience here today is a combination, lenders and realtors. We are all going to be affected by this. It is not going to hit us until August 1st of this year. So now's a good time to start. Piece of advice, don't wait till July 31st to start to think about what's coming, because unlike some of the changes that we've dealt with in the past, like the January 1st, 2010 new HUD settlement statement, this one is not going to be as easy to roll with, and there are some very particular requirements that we're going to have to meet right up front immediately. So I'll cover all of that as we get going. Like Zeb said, I'm Chad Novak. I am agency manager and counsel with Old Republic National Title Insurance Company, based here in Minneapolis, but I cover the upper Midwest region here. So I've been traveling around talking to audiences everywhere I can. We're just trying to spread the word, get everybody ready to go, up to date on expectations for what's coming. So we're going to start. I'm going to give you a little bit of background, and then we will dive in to the regulations that we face, and then we're going to look at each of the new documents in turn. So, starting with the background, I think most of us looking around the room probably were around back in the 90s and 2000s. We remember the Great Recession. Some interesting things happened back in starting 1990. Historically, home ownership rates in this country, prior to World War II, they were sitting around 40%, give or take. After World War II, as the soldiers came back, when the baby boomer generation was getting underway, homeownership rates skyrocketed at that time. Between the mid to late 40s and about 1970, skyrocketed up to about 60%. And it sat there through the 70s and 80s. Certainly the 80s were a little bit slow, because in those days, we remember, the interest rates were 15 to 20%. High rates made homeownership unaffordable. The government didn't like this, didn't like where that was going, and undertook to resolve that problem. They implemented programs that made money more available. They also encouraged lenders to then provide that money to the market to encourage home ownership. This, in turn, resulted in home ownership rates rising to about 70%. What came along with that was a lot of careless lending practices. You can blame, and if you read the headlines or you listen to various commentators, maybe you blame the lenders, maybe you blame the government, maybe you blame the secondary market, because the government entities, Fannie, Freddie, they encourage packaging and then selling the mortgages off as investment products on the secondary marketplace. You know, maybe there's truth to all of those, but what it comes down to is we found ourselves in 2008 amidst the Great Recession, and Congress reacted very quickly, and now in hindsight, in kind of a knee-jerk fashion, they enacted the Dodd-Frank Wall Street Reform and Consumer Protection Act. This has completely revised our financial services industry, not just our consumer lending for real estate purposes, what we're going to talk about today, but everything. Anything that touches finances, credit cards, personal loans. They're looking at the credit bureaus and how those report and how they come up with their credit scores. Everything has changed. This is largely under the control of the Consumer Financial Protection Bureau. That is a massive government agency that was created by Congress as part of Dodd-Frank. They were tasked with revising, among many other things, they were tasked with revising the consumer mortgage disclosures. So that would be the TILA disclosures, the GFE, and the HUD-1. The Dodd-Frank Act had a little line in it. It said the CFPB shall review the existing disclosures and recommend changes to them. That's all the Dodd-Frank Act really said to this. It's a 2,000-page long act. There's a lot of legislation in there, but federal legislation, is general in nature. It sets out guidelines, and then it is up to the various federal agencies to implement those guidelines. They then create the actual laws that govern what we do. And those laws, that's not the U.S. code, not the statutes. That's a code of federal regulations. So just keep it in mind in the back of your head, Dodd-Frank Act, 2,000 pages, just the starter. So the CFPB is an enormous, like I said, enormous regulator, enormous government agency. What you see on the screen is a summary, just some. It's an example of some of the statutes that transferred to the CFPB. Whereas these used to be governed, regulated by various different government entities, these all now fall under a single umbrella. And if you look at this, there's a lot of familiar stuff on there. Equal Credit Opportunity Act, Fair Credit Reporting, Fair Debt Collection Practices. You notice Federal Deposit Insurance Act, that's the FDIC. So as we're talking through this today, and we're talking about regulation and some of the penalties that are going to come along with the regulation in the event of wrongdoing, no one in this room should think that, oh, you know what, if I make a mistake or I do this the wrong way, they'll never find me. They're in all of our offices, especially those of you in the room who are lenders, the government auditors. The OCC is closely coordinated with the CFPB. The FDIC is under the CFPB. So they're around. They are in all of our offices and watching very carefully what we do. Gramm-Leach-Bliley Act, that's the Federal Privacy Act of 1999. HMDA, Truth in Lending, Truth in Savings, RESPA. So there's a whole lot going on here. This agency has an extraordinary amount of responsibility, and they have an extraordinary amount of power. The CFPB operates as an independent unit within the U.S. Federal Reserve, and they are kind of a sister agency to the Department of the Treasury. This government agency has an annual budget of $500 million right now. They are funded automatically with $500 million. That's just the starting point. Now, they are funded outside of congressional appropriations. I don't know how familiar you are with congressional budgetary practices, but this is a scary thing. Outside of congressional appropriations mean this is a guaranteed budget. They are going to get this funded to them every year no matter what. If Congress doesn't like what they're doing, Congress can't call them in front of a congressional panel and say, you know what, we're going to cut your budget until you fall back into line. Or maybe we like what you're doing, we're going to give you more. But the scary part is if Congress doesn't like what's going on, CFPB gets paid anyway. There is nothing else in our government that operates this way. Really, they operate as if they are a dictatorship inside our U.S. government. They're in a bubble. They're insulated. You think about the NSA and the CIA, their budgets are set by Congress. Congress doesn't like what these secretive groups are doing. They can adjust the budget. They can direct activities based on funding or lack thereof. CFPB, no such thing. Take it a step further. Here's the really scary one, is this last bullet point on your screen. Additional operating capital is derived from fines and enforcement actions. Here's a group that is incentivized to go out, find violations, and assess fines. All right. A significant portion of their budget comes from these activities. That's scary. There's nothing wrong with government regulation. Certainly, this is for good purposes. The goals here, specifically as to the documents that we're talking about today, the goals in these documents, it's to help consumers avoid costly surprises at the closing table, to allow them to achieve easier comparisons of the estimated and final loan terms and fees, give them more time to consider their choices, and put limits on closing cost increases. These are all good things, right? These all protect consumers. The problem is that when a group is incentivized to find wrongdoing, holy cow, they're going to be voracious in seeking out, and in fact they have been voracious in seeking out and assessing fines, assessing penalties. I like to compare this to a traffic cop. So imagine you're driving here today, you're coming down the street, speed limit's 45 and you're doing 50. A cop pulls you over for doing 50. There's a good chance probably that they're going to give you, as long as you're not a habitual speeder, right? They're going to give you a written warning or let you off. Or maybe they'll knock it down. If you're doing 11 over, maybe they'll knock it down to 9 over so that you're not paying the big fine and maybe it's not the mark against your driving record. But imagine instead that cop who pulls you over gets to determine what the fine is going to be, and then he gets to pocket whatever he manages to wring out of you. Think about that. How different is that situation? That you get pulled over, how different will that be if that cop is actually incentivized? That is the context that I want all of you to keep in your minds as we go through this and as we go forward. I'm not a paranoid person by nature, but this scares me a little bit. This might change. The Republican Party, and even some Democrats now, it is becoming more of a bipartisan effort. Hindsight being what it is, they're looking back at 2010 when this was created, and they're saying now, holy cow, what did we do? This needs to change. The Republicans, thus far, the party has promised that if they take control of both houses of Congress in Washington, D.C., that this is pretty much number one on the agenda, is to fix this. They're thinking about, instead of having one person in charge of the CFPB, making it a panel, make them answerable to Congress. So we might have changes. Those changes in structure are not, however, going to affect the documents that we're talking about today, the processes. And it's not going to change the fact that ultimately this is an agency that was created to protect consumers. That's their goal. They will continue to do that. So we'll look at a little bit of the CFPB history and what they've done. They were established in 2010. They've not even been active that long. These are a couple of handful of fines, some examples of fines on the screen that they've handed down. These are just some of the bigger ones. I went on their website. They're very proud, by the way, of their enforcement actions and the fines that they assess. They like to send out press releases every time they find a wrongdoer. They like to virtually brag about the fines that they're assessing. Good for them, but scary for those of us who practice in the industry. So some examples. Bank of America had to pay $727 million to consumers for illegal credit card practices. On top of that, they paid $20 million as a fine directly to the CFPB. GE Capital, $225 million to consumers, $3.5 million on top of that directly to the CFPB for deceptive credit practices. Amex, $10 million to the CFPB, deceptive marketing and unfair billing. Wells Fargo, $24 million to the CFPB for illegal mortgage kickbacks. They were paying for business referrals. JP Morgan Chase was involved in that one as well. They got off the hook pretty easy. They only had to pay $600,000 to the CFPB. U.S. Bank, $5 million to the CFPB for unfair credit card charges. So these are some of the lender fines. This is serious stuff. For every one you see on the screen here, there are 8, 10, maybe a dozen others, smaller lenders who are also paying fines. The CFPB is out to put companies out of business if they're not handling their business appropriately, if they're not following the law. So be very cautious in what you do. Likewise, RESPA Section 8. For those of you who don't have RESPA memorized, that's the portion of RESPA that says there shall be no kickbacks, referrals, or other unearned fees as part of a consumer real property transaction. RESPA was enacted in 1972 because the government at that time was looking at consumer real property lending practices and realized that there were a lot of people with their hands in the till. There's a lot of padding going on, a lot of additional costs, kickbacks, payments for referrals, with the net effect of increasing the cost to consumers. The U.S. government said, no, this has to stop. They enacted RESPA. HUD oversaw RESPA. HUD, of course, now part of the CFPB. The CFPB has a real affinity for RESPA Section 8. And it was funny, in a financial journal in mid-February, there was an article, and I love the headline. The headline was, CFPB to RESPA Section 8, will you be my Valentine? It's because they are going after Section 8 violations. Everything on the screen here is pretty recent. The first one, a series of private mortgage insurers, PMI companies, who collectively had to pay $15.4 million to the CFPB as a fine for kickbacks to lenders for making business referrals to them. Amerisave Mortgage had to pay $4.5 million for mandating that their borrowers use their affiliated title company. They also gave inaccurate rate quotes, and they required consumers to pay upfront fees for mortgage applications. Not just we have to collect $50 to pull your credit report. You can do that up front, but Amerisave is collecting $300 to $500 just for the privilege of reviewing a consumer's loan application. Strictly prohibited. New Day Financial, $2 million fine for deceptive marketing practices, attempting to direct business. They were advertising, insinuating that they were a preferred lender for the VA, when in fact that kind of advertising is illegal. JR-HBW Realty, I had to back down to some of the smaller guys here just to show that, nope, they're an equal opportunity enforcement bureau. JR-HBW Realty, $500,000 for mandating use of an affiliated title company. So the realtors there were directing their buyers and sellers, you have to use our title company. When RESPA specifically reserves the right to buyers to choose their own title company, it cannot be unduly influenced. And then Lighthouse Title, $200,000 for violations related to entering into marketing services agreements. Now this I'm going to take a second to talk about briefly because marketing services agreements are pretty common. What is that? That is when two or more parties who are in a position to refer business to one another enter into a joint marketing agreement. Maybe you put your logo on a flyer with another company's logo, a lender and a realtor. Since that's who's in the room, we'll use that as the example, and you market together. That's okay. HUD in years past has provided guidance saying marketing service agreements are not per se illegal. Rather, the parties participating have to receive equivalent value for the money paid. So if there's a marketing piece going out, the lender's sending it and they invite a realtor to advertise, they can't make the realtor pay the full bill for the lender's advertisement. Rather, the realtor has to pay reasonable market value for the service provided. Otherwise, the government looks at that as an illegal kickback. It's padding, it's payments. It's I'm giving you something of value with the assumption that you're going to give me business in return. There cannot be this quid pro quo. Lighthouse Title got fined $200,000. They're a Michigan title company. In fact, they're an Old Republic. They're one of my company's agents, and they're a nice agent. We've been working with them for years, and I've worked personally with them in the past. They're great. But the Michigan market was a pay-to-play type of market. And this is in the consent order they entered into with the CFPB where they acknowledged this. Unfortunately, Lighthouse Title was the one who got hit with a fine. The CFPB took an interesting approach, though. They looked at Lighthouse Title and they looked at the marketing service agreement, and they then, as part of their investigation, found that Lighthouse Title didn't do the research to determine whether or not the value they paid for the advertising, whether or not they received equivalent value for what they paid, whether or not they were unfairly or compensating the lender for the advertising. CFPB said we didn't even have to get that far because the marketing services agreement, just entering into that, that's a thing of value. They didn't come out and say that that's illegal, but their commentary is interesting, and there's been a lot of chatter on the legal blogs on this matter because HUD always said marketing services agreements are fine. You have to look behind it to the money flows, the value provided. CFPB stopped right there and just said, this is a thing of value. So right away, we've hit a violation here without even looking behind it. Again, not necessarily illegal per se still today, but certainly under much stricter scrutiny than they ever have been before. So it's a caution to those of you in the room who might advertise with your business partners. So the final rule. I told you to keep in mind, Dodd-Frank, 2,000 pages, and one little line in there said, as part of creating the CFPB, you are tasked with looking at the consumer real estate transaction disclosures and recommending changes. Instead of just recommending changes, the CFPB took it upon themselves to completely revamp the entire way we're going to do our business starting August 1st. That one little line in the Dodd-Frank Act, CFPB has come back with 1,888 pages worth of instruction, worth of information. When I said, I was comparing the U.S. Code, the federal statutes, to the Code of Federal Regulations, which actually implement statutes, one line of 2,000 pages turned into 1,888 pages. Those of you, if any of you have been in a law library, if there are any lawyers in the room, you know that the U.S. Code, if I put it in small books on a bookshelf, it would take up not quite even one wall in this room. The Code of Federal Regulations would fill up every building in this entire complex and then some. So it's enormous. That's what implements the law. So this is what we got. If anyone in the room, you have insomnia issues, please just read this. I guarantee you it's a surefire cure. I have read Dodd-Frank. I have read this. It is not thrilling. Fortunately, I'm going to make a quick recommendation here. When you leave here today, if you have additional questions or you haven't memorized everything I've said over the next hour to go, CFPB has issued the Small Entity Compliance Guide. You can see here it's not 1,888 pages, it's 91 pages. And it is a wonderful, concise summary of the things that we're talking about today. The new disclosures, the time frames involved, and how this whole thing works. It's available on their website. You can go to cfpb.gov, or you can go to consumerfinance.gov, or you can just Google Small Entity Compliance Guide. Wonderful tool. It's a wonderful tool. I recommend looking at it. Okay. So this is the rule, and this is what's going to turn our world upside down starting August 1st. That's the implementation day. Again, I'm going to stress, don't wait until August 1st to decide how this is going to work. I'm glad you're all here today. You're taking those steps to learn what's coming and hopefully prepare for it. The new rule applies to applications, loan applications that are taken on or after August 1st, 2015. It does not apply to loan applications that were taken prior, no matter when it closes. It could close after August 1st, doesn't matter. We have to use the new documents for loan applications on qualifying loans. Qualifying loans, we'll talk about that in a second. Applications taken on or after August 1st, 2015. What does this mean? It means we're going to have two different standards going forward. We are going to have the current one we're familiar with, using the Truth in Lending, the initial till, the final till, the GFE, and the HUD-1. That is one track. That will be going forward. The second track is the new loan estimate and closing disclosure and the timelines affiliated with those documents on those qualifying transactions. Lenders in the room, we're going to be juggling this like crazy. And the rest of us are going to have to rely on the lenders to tell us what track are we on here. Because the HUD-1 doesn't go away. It's going to be with us for a long time to come. The lenders are the ones who know. We're just going to have to listen, follow their lead. Unlike January 1st, 2010, when we had the revised HUD-1, and HUD encouraged all of us to start using it before January 1st, 2010, we cannot start this early. We may not, strictly prohibited, to use the new forms and the new timelines before August 1st, 2015. Hopefully, for those of you in the room who are lenders, your organizations will be working to do some dry runs on this. You'll do some practice behind the scenes so you can figure out how these timeframes are going to work, make sure that you're ready for it come August 1st, because we cannot delay implementation. The Mortgage Bankers Association and the American Land Title Association and others in the industry have approached the CFPB and have said, will you please restrain enforcement of these matters? Because this is a whole new world. This isn't just some changes and some tweaks. It's a whole new world for us. We need time to adjust. Richard Cordray, he's the director of the CFPB. Richard Cordray said, no, there will be no restraint. That 1,888-page stack of papers, the final rule that they call it, that came out November 20th of 2013. By the time August 1st, 2015 rolls around, we will have had nearly 2 years to work through this, figure out what we do, and acclimate ourselves to it. So he said, no, we are not going to exercise restraint. He backpedaled ever so slightly and said, maybe we won't be quite so aggressive with our enforcements. Reading between the lines, I hear that to say the fines might not be quite as big, but otherwise, August 1st, it's a drop-dead date. Very serious about that. So what does this apply to? It's the majority of closed-end consumer mortgages. This changes a little bit from our current and historical RESPA definition. RESPA applied to mortgages, consumer mortgages that had a governmental slant to them, some governmental involvement, be it it's a Fannie or Freddie or VA mortgage, FHA, something like that. Now, this is a Consumer Protection Act, not a Government and Consumer Protection Act. So this is the majority of closed-end consumer mortgages with very few exceptions. The first two of those exceptions are reverse mortgages and home equity lines of credit. If we have a reverse mortgage or home equity line of credit, those will continue to close on the existing HUD-1. If it's a mobile home or it's a dwelling not attached to land, that does not constitute real property, so it's not truly a mortgage transaction. It's personal property. It's a vehicle, basically. So this doesn't apply. Commercial loans continue to get the pass. Creditors making 5 or fewer loans per year. The seller take back on occasion. The informal lender, they don't have to follow this rule. Certain no-interest subordinate special purpose loans get a pass. These are the community investment or community enhancement loans, foreclosure rescue, quick foreclosure rescue loans, things like that. Very limited circumstances for those. And cash transactions, of course, continue to get the pass. Otherwise, if it's a consumer transaction, these new rules are going to apply. Consumer transaction being a 1 to 4 family residential property not entered into for business purposes. So not an investor buying a home, but rather a consumer who's going to be occupying one of the units is buying that home. I've talked about the fines. I gave you a little break to let it set in. Now we're gonna hit it hard again. We circle back here because I really want this to be impactful to you, and I want you to think about the circumstances where these things might arise. CFPB has very broad enforcement powers. They are enforcing both TILA and RESPA. They've brought the violations together, and here's what we're looking at. CFPB fines. This has nothing to do with any liability you might have in a court of law, because there is other liability that comes under these statutes. This is purely the fines that the CFPB may assess if there's a violation. We start at $5,000 per day for a violation. That's a mistake, innocent mistake. I transposed some numbers. I got my closing numbers wrong. I didn't realize that somebody in my office didn't send out the disclosure at the right day. Innocent mistake. $5,000 per day per violation until it's remedied. On a lot of these violations, the remedy may never come. Maybe you find out about it as part of an investigation, and that's not going to be the day after it closes or the week after the loan closes. It's probably going to be months down the line. Even if you realize you've made a mistake and you go back and you fix it, you redisclose, you send the consumer the proper documents, you refund money that might have been collected in excess, and you get them to re-sign the proper documents. Even in those cases, $5,000 a day until it's remedied. We step it up to $25,000 per day for reckless violations. What is recklessness? It's a legal standard. It means you should have known better. It means that in that 1,888 pages, we gave you very clear direction and you misinterpreted it. You took the wrong approach here. $25,000 a day. But those pale compared to that third line, $1 million a day. Every day until it's remedied when we have a knowing violation. That's where we knew better, we knew what we should have done, and we chose to do it a different way. This will come up most particularly when we're talking about the timelines. Now, instead of the HUD-1 showing up at closing, adjusting it at the closing table, technically, it's supposed to be in the consumer's hands at least 24 hours prior to closing. We know that doesn't happen in a lot of cases. And there's not been strong enforcement mechanisms behind that. Now the new forms have very specific disclosure timelines. We'll go through them, but one of them, 3 days prior to closing, 3 business days prior to closing. That's the settlement statement, 3 days prior to closing. So we have to take all that shuffling we're doing at the closing table, and we have to bump it up 3 days. And you're going to see that actually means a lot more than 3 days in advance. Let's say we come down to that, and we can't get that thing out in time because your consumer's rate lock is about to expire. It's going to expire in 2 days. And if you don't close it within 2 days, they're going to have to pay more or their rate's going to go up. Or maybe they've got a debt that they have to pay and they need that refinance to close right away because they need that money so they can pay that other obligation. The moving truck's in the driveway. We got to go. We got to get into the new place. If you bend the rule at all, that is a knowing violation, $1 million per day fine. No joke. Until that's remedied. And to remedy it means you have to start the whole transaction all over again. And again, I will stress, even if you fix it, the violation has still happened. It just caps your liability at the date when you fix it. Doesn't mean that it makes it all go away. $1 million a day. So when the lenders, I should say, pause and say the lenders are the ones who are under the microscope here. The CFPB has said they are enforcing violations against lenders. That doesn't mean that those of us in title, those of us who are realtors in the room, doesn't mean we get a pass. What it means is that we have to be great business partners for the lenders. They have to be able to trust us and rely on us, and we have to prove ourselves worthy of that trust. Otherwise, we might have some trouble doing business with those lenders. Certainly you don't want to be on the receiving end. Well, you don't want a lender to be on the receiving end of a fine for something that you might have created or influenced. $1 million a day. So when the lender says, no, we absolutely cannot close until next Tuesday, they mean it. This is why. So just keep that in your mind as we talk through these things. They're very serious. The CFPB is very serious about this, and they're looking. Remember, they're incentivized to find these errors. They're looking for this stuff. So I've mentioned it. We're going to look at these 2 new forms. We've got the loan estimate that's taken the place of the initial truth in lending, as well as the good faith estimate of settlement costs. It's a 3-page document. And then we've got the closing disclosure at the back end of the loan transaction, taking the place of the final till and the current HUD-1. That's now a 5-page document. So we've got 8 pages worth of new documents, 1,888 pages worth of direction on this, or just read the 91-page summary. Hopefully your compliance departments are reading the whole 1,888 and sleeping well. Okay, so this is fun. I read to you, excuse me, I'd read to you some verbiage directly from the CFPB. The goals: help consumers avoid costly surprises, help them achieve understanding of the transactions they're getting into, put limits on closing cost increases. All good and valuable purposes. But the CFPB not only revised the procedures, but they also gave us some new lingo. This is fun. Lender, those of you lenders in the room, you're not lenders anymore. Going to have to trade in your business cards and get new ones because now you're a creditor. Borrowers are no longer borrowers, they're consumers. I think that might have come out of the foreclosure debacle here, because borrower would imply you have to pay back the money, whereas consumer, it's an ulterior motive here somewhere, I'm sure. Tolerance, we have the tolerance buckets on the HUD-1 starting in 2010. We have the tolerances. Those are now variances, because tolerance would imply that we tolerate changes, and in fact we do not. And you'll see how serious we are about that. So it's now a variance. And the final one I love, have you seen this? Now closing and settlement, these are consummation. It's consummation. So now we're consummating loans. I'm your consummation officer today. When would you like to consummate? Here's your loan package. This is a nice table. Would you like to consummate here with me? How creepy is this, right? Thank you for not running out the door. How many times is your HR department going to call you in saying, you got to stop consummating with people? This has really gotten awkward. This is great. So thank you, CFPB. This is your tax dollars at work. Thank you very much. You know what's ironic is they've given us this lingo. They've said these are the words you're now going to use here in the industry. The new forms that we're going to look at here, they still use lender and settlement. They don't even follow their own instructions. So that's funny, but we have to. I'm pretty sure there aren't fines behind this, though, if we don't consummate and we settle instead. All right, so let's get into the documents themselves. The loan estimate. The loan estimate is the initial disclosure. Creditors have only 3 days to issue the loan estimate once they have collected an application. We have 2 different day standards. The first day standard is this one. That's 3 days, business days for the creditor. That's days when their offices are open and they conduct the majority of their business with the general public. So if you are a bank and you're open on Saturdays and you're conducting business on Saturday, then Saturday counts. If you're not open Saturday or Sunday, those days don't count. It depends on the nature of your business as to when you start to count this thing. So the clock begins to run, like I said, after the application is taken. The CFPB has defined a loan application as the 6 items you see on the screen. It's the consumer's name, their stated income. This isn't their pay stubs, this is their stated income. Their social security number, the subject property address, the consumer's estimate of the property value. Of course, if it's a purchase transaction, we're going to have a PA, and that's going to tell us what the property value is. But if it's a refi, it's whatever they say their property's worth. We know they're pretty accurate on that all the time, aren't they? And then it's the loan amount, their estimated loan amount. When you have those 6 pieces of information, many of which are guesses at best, you then have to put together the loan estimate. And this loan estimate has to be pretty exact. That's one of the words that should have been on that last screen. Estimate equals exact, because we got to dial this in pretty carefully, as you'll see on the next screen. But before we move on, lenders, you cannot duck one of these in an attempt to delay having to send out the loan estimate. You can't tell your consumer, all right, I've got 5 pieces of information, but tell you what, we're not going to talk about how much you want to borrow. We'll discuss that later. You can't duck it. Doesn't mean you can't pre-qualify, because a pre-qualification, you're going to skip out on a lot of this. You're certainly not going to have a property address or the estimated property value when you're pre-qualifying. So you can do that. But once we have this information, you cannot dissuade the consumer from giving you all of these pieces of information in an attempt to delay the disclosure requirements. 3 days to collect this and get it out. So what is the loan estimate? Like I said, not really an estimate. You've got charges that have to be exactly reported. These include the creditor's own charges for its services. These also include charges for services that the creditor or the mortgage broker's affiliated business provides. So if they have a related title company, if they have an appraisal service, if they have a flood determination, flood zone service, whatever it may be, to the extent that that organization or a related affiliated entity is providing those services, these must be exactly stated on this loan estimate based on 6 pieces of information, a lot of which is going to be inaccurate. Also, charges for services for which the consumer may not shop must be exactly reported. If we don't let them shop, you got to nail it dead on up front. The biggest one that we're going to wrestle with, you see on the screen, that's the appraisal fee. So I've been talking to realtors, lenders, builders all over the upper Midwest here, giving this presentation, and I've been asking them what kind of fees do they see. And in any given market, I see variances of anywhere from $150 up to actually $800. This is for a different appraiser appraising the exact same property, the same exact service, wide range. If you're a lender and you have various appraisers on your rotation, you need to be certain that whatever you're quoting as their fee is dead on, because that's a service for which the consumer may not shop. So the easy answer to this one is, okay, maybe the appraiser, or it might come in at $700. Tell you what, I'm just going to quote $700 all the time, maybe even $900 or $1,000 just to be safe. That way I'm never exceeding the tolerance. This doesn't say tolerance, doesn't say variance, it says exactly reported. This is going to be a real struggle. Now, I've said it before, I'm going to say it again, this is here to protect the consumer. That's the goal of what we're doing here. Certainly, we don't want surprises at the closing table with inflated costs, but you'd think it's not harmful to the consumer if you told them the appraisal is going to cost $1,000. It comes in at $500. If I'm sitting down at that closing table, I'm thrilled. You know, that's $500 back into my pocket that I thought I'd have to spend. The CFPB is probably not going to bring an enforcement action against you because you said it's going to be $750 and it comes in at $500. Because again, you've got the stable of appraisers. You're never going to know precisely what it's going to be in all cases. But we have another piece at work here, and that's truth in lending, and that is an APR restriction. So your APR can't fluctuate very much. We're going to look at that a little bit later on. Your APR can't fluctuate very much. So if you're quoting all your fees very high up front, and then by the time you get to closing, they've all trickled down, now you're outside of that pretty narrow APR band, and you might have some issues there. So I don't have an answer on all the points that I'm going to talk about today. I'm just talking about some of the pain points. This is up to each and every one of you, your compliance department, to figure out what your tolerances are. Other charges have to fall within 10% of the estimate. And these are in the aggregate. It's not per line item 10%. It's in the aggregate. And those are the charges for service providers that the lender identifies. When they send out the loan estimate, the lender has to provide an additional sheet with a list of service providers for those services for which the consumer may shop. One of those is the title insurance company. So the lender has to provide the list. They can't skip that step. They have to provide at least one name in every category. They don't have to provide 3 or 5, at least one. And if the consumer decides to go with whomever's name is on that sheet, is on that list, then we have to hit within 10%. So that means that lenders are going to be talking to their affiliates, not affiliates, I shouldn't use that word, but their business partners who might appear on that list and making sure they've got those fees pretty well nailed down, because they don't want to give a quote, have the consumer go with one of the companies whose name they provided, and then find out, whoops, we have a violation here. So it's really, throughout this whole thing, communication is going to be very important. I've been talking about the lenders a lot here. Realtors, I'll get to you. Your time's coming too, so don't think you're off the hook. Other charges have to fall within 10% of the recording fees. Other charges for which the services for which the consumer may shop, and they do not select from that the identified service provider list, there's no cap on those fees. So they can vary by any amount, not a problem, no violation, no penalty. The lenders are still under the obligation of making a good faith effort based on whatever information is reasonably available to them at the time of the loan application to disclose those fees as closely as they can. There's a lot of stuff here. They're going to rely on us, the rest of us, the other real estate professionals, to help them obtain information so that they are making that good faith effort. And these fees include things like title insurance. If it's an off-list title insurance provider where they close, well, then we still need to make a good faith effort at getting the title insurance as close as we can. Any escrow fees, any transfer taxes that may be due, charges for home warranties, HOA fees, recording fees, homeowners insurance, flood insurance, personal property purchases. If you're a realtor, your client is buying a home and they've also contracted in that PA for some personal property, they're going to buy some of the furniture or some appurtenance. Make sure that you're drawing that out to the lender. The lender really needs to know about this, so point that out specifically. If there's any kind of seller credits, we need to let the lenders know right away. Realtors, your time has come. Here you go. Second from the bottom on the left side column, HOA fees. I'm sorry if any of you are HOA people here, if you head up your HOA, but we know infamous. HOAs are infamous for being very slow to respond when we ask them for what is the payoff, how much is due, what's the cost to transfer. They oftentimes surprise us at closing. Oh yeah, we've got the move-in, move-out fee that we forgot to tell you about. They will pepper you with fees, and they're not very quick to respond. This is going to be a major pain point going forward because our timelines are so tight and so particular that we need this information sooner than ever before. The reality is that probably as part of this, when we start to look at the timelines, it's actually going to extend our timeline. So if we're closing right now in 30 to 45 days, I think that might be difficult. I think we're going to be extending at 45, maybe to 60. I've had a couple lenders in other markets say, I don't see how we can get this done in less than 90. So timeframes are going to change. Communication is going to be very important, but here's where it starts for you realtors, HOA fees. If you're representing the sell side, I think everybody's going to look to you to really help us collect these fees. Help, if the HOA is not being responsive, we need to rattle their cage because this is very important. We can't have these delays. It's going to slow down the closing. We might miss our closing date and is going to cause quite a hassle for everyone involved. So all of us, I think, are going to be leaned on by the lenders to make sure that we are assisting them in every way possible. We're not just serving our own interests and our clients' interests directly. We're now serving the interest of everybody involved in the transaction. It's on all of us now, and that's why we're pulling these presentations together to get us all together. We do need to, all of us, step it up, do this, approach things a little bit differently than we ever have before. So there is a title insurance quirk in the loan estimate and in the closing disclosure, and this is something that we are going to have to discuss with our clients. Fortunately, here in Minnesota, we're not in a jurisdiction where the seller customarily pays for the purchaser's owner's title insurance, but sometimes that does happen. There are 31 jurisdictions in the U.S. where that is actually the standard. It's the norm. In those 31 jurisdictions, this is going to cause a real nightmare. The documents aren't going to balance, and I'll explain why in a second. In 21 states in the U.S., we're breaking state law by doing what the CFPB has told us to do because title fees have to be disclosed accurately on these any kind of loan disclosure. And in fact, the CFPB has told us you are not to disclose these accurately. You have to lie. So here's why. The loan policy has to always be shown at full premium. If the consumer may be receiving a discount because it's a reissue rate, perhaps because they're doing a refinance or a refinance rate, or if the more common one on a purchase, if the owner's buying an owner's policy, the loan policy rides along at the simultaneous issue rate. It's steeply discounted, commonly anywhere, depending on the jurisdiction, $50 to $250. A big discount from the original face value of that loan policy if it was going to stand alone. Loan policy has to always be shown at full premium now. Why? Because we want this to be as accurate as possible. The borrower may or may not purchase an owner's policy. The lender is always going to have a loan policy. And so you don't want to quote the simultaneous or reduced fee loan policy and get to closing and, oh, surprise, it's actually more expensive than we thought it might be. So the CFPB says we have to quote that at top dollar. Owner's policy then is quoted at the incremental difference between the loan policy and the overall title charges. I'm going to walk you through the calculation quickly so you understand it because it is going to look funny to all of you and to your clients. We want to make sure everybody understands it. So title insurance underwriters, my company and others like mine, we are insurers, we're heavily regulated, and we have to file, in most states, we have to file our insurance rates with the state regulators, the Department of Insurance. Here in Minnesota, it's the Department of Commerce. and those rates have to be approved for use by the regulators. We then have to charge what we have filed. It protects consumers. I can't file a $1,000 owner policy at a certain level and then charge the consumer more. We don't want to price gouge them. We want to protect them. Our filed rates must reflect the nature of the risk that we assume when we issue the policies. When we're insuring owners, we're insuring the essence of title. We're insuring the fee, that they own it, that no one else has an interest in that property. It's theirs, and they can peaceably enjoy it free of interference. There's a lot of coverage in the owner's policy. The owner's policy could also potentially have liability on it forever, depending on how subsequent events go. Even after the owner sells, there might still be coverage if there are covenants of warranty that extend down the chain to each subsequent purchaser. That can, if there's a title defect, it can find its way all the way back up to that owner, and they've got coverage on that policy. So it doesn't, in a lot of cases, doesn't ever go away. Loan policy, on the other hand, is for a lower value because lenders typically, these days, we're not loaning 125 or 150% of value. So oftentimes it's less than the owner's policy, the purchase price of the property. Loan policies also, every month as the borrower, or the consumer, I should say, makes the payment on the loan, that obligation, the debt obligation, is reduced. And so my risk, my exposure under that policy is reduced, and eventually it's paid off, my risk goes away. Typically in relatively short fashion. So the loan policy is a less expensive product. The loan policy, like I mentioned, often rides along at a simultaneous discount. So how do we do the calculation here? We don't do it that way. What we do is we add up the total amount of the insurance. For argument's sake, let's say the owner's policy is going to be $1,000. And let's say, for argument's sake, that the loan policy, if taken out at the same time as the owner's policy, it rides along for only $100. So $1,100 total bill. The loan policy, however, were to stand alone. If the owner doesn't buy an owner's policy, the loan policy might cost, let's say, $700. But because they're doing it with the owner's policy, they get it for $100. We have to disclose the loan policy at $700, notwithstanding any discounts, $700. And then the owner's policy is the incremental difference between the total title charges and that full price loan policy. It's the difference between the $1,100, 1,000 owners, 100 simultaneous loan, minus the $700 full price loan policy equals $400. So the owner's policy that we charge $1,000 for is actually disclosed as $400. So the twist is, if you have a seller who is contributing to the buyer's title policy, let's say they agree to split it 50-50 or they agree to purchase it outright, these would lead you to believe that they only have to pay $400 for that owner's policy, when in actuality what we're charging for it is $1,000. Okay, I've spent enough time on that. I want to introduce that. So that's in your head. When you see these, it's going to look funny. Usually the title company is going to give you a separate sheet explaining the calculation. We're going to have to do it that way. A lot of the rate calculators have been tooled to disclose it in this fashion as well, show the actual charges, but nope, here's how the CFPB tells us to disclose it. So we'll move on. The loan estimate. Now, we're not necessarily locked in on the loan estimate. There are changes of circumstances and times when redisclosure is necessary. If the information provided by the consumer is inaccurate, you can make changes. Like I said, their stated income or their assessment of the property value. We know they're rarely dead on either one of these at the time of application. So if the lender finds new information, different information, if the consumer's information was inaccurate, and that affects one of the fees that was disclosed on the loan estimate, one or more, then the lender may reissue it, has to reissue it within 3 days of finding out the new information, get it back out to the consumer. If there's discovery of new information that's specific to the consumer transaction, information not previously known. There's a surprise in the title exam, and they find out, whoops, we've got to do some curative work, it's going to cost more. Whatever it may be, that's a nice little general catch-all. Discovery of new information not previously known that would change a fee on the loan estimate. It can be redisclosed, reissued within 3 business days to the consumer. This does not mean, in any of these categories, it does not mean that the lender has carte blanche to change other fees. Let's say we find out that the value of the home is not what the consumer thought it was. That doesn't mean that if the lender said the appraisal is going to cost $500 and it actually comes in at $750, that doesn't mean they can adjust the loan estimate as to what they disclose the appraisal fee at. Because no matter what the home value comes in, that doesn't affect how much the appraiser gets paid. So they can't change that. But if that loan value comes in lower than estimated, and now suddenly we have to reduce the loan amount, Then, of course, anything affected by the reduced loan amount, those numbers can be changed, redisclosed. If the consumer requests a revision, they applied for a 15-year and they want a 30-year, something like that. They want to change the loan product. That's just fine. Again, only changing on the disclosure those numbers affected by the change in loan product. On the day of locking the rate, if the consumer has not yet locked the rate, they've made application, they've received the loan estimate, they haven't locked the rate. When that rate lock day comes in, chances are the rate has changed, and that has affected things like the points or the lender credit. That can be redisclosed. Those things affected by this can be redisclosed. After the 10-day expiration, this document is good for 10 days and only 10 days. If the consumer has expressed an intention to move forward with the loan during those 10 days, then what's on the loan estimate, unless affected by another category, they're locked in. After 10 days, if the consumer calls a lender up on day 11 and says, hey, I'm ready to move forward with that loan, let's do it, the lender can say, nope, new loan estimate. It expired, it's done, throw it out, not bound by it in any way. So for those of you, I guess all of you, when your clients are applying for loans, make sure they're aware. If they want to move forward, if they like what they see on the loan estimate, they want to move forward with it, they have to affirm that within 10 days. Otherwise, that's out the window, we start over again. And then in the case of an extraordinary event, that's the act of God, the fire, earthquake, flood, tornado, war, rules are out the window when these things happen. Otherwise, it has to fit into one of these very narrow categories in order to permit any kind of changes. Now, the loan estimate has to be in the consumer's hands at least 7 days prior to closing. So you can't issue the loan estimate, have it delivered within 3 days, and then close right away after that. It has to sit in their hands at least 7 days. Usually not a problem at all. But if we get down toward closing, we're on tight time, and something changes that requires a new loan estimate, let's say you get to the closing table a couple days before closing, the consumer says, hey, never mind, on the 15, the payment's too big, I want the 30-year. You have to reissue this thing, get it back out to them within 3 days of that new information, and then we have to wait 7. So that's going to throw a wrench into the system here. That's one of the big hitching points. We're going to take a look at the loan estimate now. I know it's kind of small up there on the screen. These are all available on the CFPB's website. And in fact, this is the CFPB's example that we're using. The documents themselves are really nice. They're very clear and easy to read. The loan estimate here, first page, loan terms, loan amount, interest rate, monthly P&I. Down at the bottom, what's the estimated closing cost and what is the estimated cash to close? It's the key information the consumer wants to know. It's laid out very clearly and plainly. It's a nice document. Now we get to page 2, and here's where the fun begins. Remember, the CFPB wants consumers to understand the transaction they're getting into. How do we do this? We do this by eliminating the line numbers. Now you'll see the closing disclosure is going to look a lot like this. They operate much the same way. No line numbers and actually really no organization. There's broad categories of organization, such as Section A on the upper left column there, origination charges. Section B, services you cannot shop for. Section C, services you can shop for. Under each one of those headings, then the lender will arrange the fees accordingly. But the lender doesn't arrange the fees however they see fit. These aren't hard-coded in there. Instead, the lender calls each individual line item fee whatever they want to. So the American Land Title Association did a quick survey nationally, and they came up with 54 different words and phrases that we use all around the country to refer to the appraisal fee. We can call it any one of 54 different things. You can call it anything you want. You know what the CFPB really cares about? It's that it's in alphabetical order. Because if I'm the consumer and I'm reading this thing and I see credit report fee, flood determination, tax monitoring fee, and then I see appraisal fee, my mind's blown. I don't know what just happened. God, how does A come after F? I'm done. This is what they've instructed us to do. We don't care what you call it, but in each section arrange them alphabetically. It's kind of silly. Not the only thing, obviously, that's kind of silly. Who's ready to consummate, right? Come on. All right. So the totals in this, you're going to walk out of here going, God, that guy was so creepy. He wants to consummate. The totals in each section, the line items, they add up to the top of each segment in A, B, C, D, and so forth. And then each segment, then, the grand total, those are totaled down to the bottom of the page. So there's some up and down. So if you're closing, we're drawing the consumer's attention kind of zigzaggy around the document. But it lays it out clearly, and thank God it's alphabetical. This is page 3. Page 3, this is what the CFPB really wants the consumer to use to shop. They want to encourage the consumer to shop. They want them to get the best deal. They don't want anybody shoving them into a product that they're not ready for or don't understand. And so up near the top, we've got the comparison box. And the comparison box shows in 5 years what is the total amount the consumer will have paid in interest, mortgage insurance, and loan costs and principal, and also how much principal will have been paid off at the end of those 5 years. Then it discloses the APR, and it discloses the total interest percentage. The CFPB, Richard Cordray, director of CFPB, he's a smart man, by the way. He was a Jeopardy champion back in the 80s, and he came back for the Tournament of Champions more recently and walked away to take over the CFPB. So, smart guy, former Attorney General of the state of Ohio. He made some public comments late last year, several different times, where he laid out what the CFPB wants to see, which is consumer applying for multiple loans. They get these loan estimates, you lay it all out nicely in the table in front of you, you look at 6 or 10 or 12 of them, and you pick the one that looks best. And he said, that will have no adverse effect, of course, on the consumer's credit. This is a positive thing, and we all know that every time you apply for another loan, your credit score falls. And when you get the first loan estimate, because your score, your fees were set and your score was an 820, and now 11 applications later, you've dropped down to a 775, that first lender's loan estimate, that's going to change now, because when they hit your credit again, all of a sudden your credit score's dropped. CFPB told you they operate in a bubble. They are a bubble, and here's one of the issues. I mean, shopping around's a good thing, but actually putting in applications all over town, we know that is harmful. So that's the loan estimate, 3 pages right there. Now we move on to the closing disclosure. This one is the one that we're all going to struggle, I think, the most with. So, good news is ahead, right? We go from bad to worse. By the way, don't shoot the messenger, please. I'm just here to deliver the message. It doesn't change what it is. And the reality of the situation is that we have, those of us who've been in the industry over the years, we've seen many changes. We're always in flux. There's always something going on that's different. We're going to look back 2 years from now and go, not a big deal, because we're used to it. It's our new normal. Just like we look back to 2010. I remember January 1st, 2010, oh my God, the sky is falling. We don't know how to work this new HUD-1. That pales in comparison to this. We get past that, we're going to get past this too. But in the meantime, it'll be a little bit of a bumpy road. And this, I'm going to take a little pause to talk about communication. When we're talking about the loan estimate and changed circumstance that requires the lender to redisclose, really they are relying on the realtors. They're relying on the title companies. They're relying on anyone who is really playing a big role in the settlement transaction and the loan application transaction to feed that information through to them. So we all need to communicate very clearly. If you find out that your consumer, your client has new information, something happened, they changed jobs, maybe they enter into purchase agreement addendum, changing the terms of the deal a little bit, that needs to get passed through to the proper channels, first and foremost the lender, very quickly. So communication is key. For those of you representing clients, make sure your clients are aware too. Let you know as soon as anything might change, no matter how mundane. We have to let everybody know, because it could affect the entire process here. Could require some redisclosure, could bump the time frame. So there's my public service message. So the closing disclosure, I've talked about it a little bit. It's not going to show up at the closing table and do a bunch of juggling with it. At that point, it has to be out well in advance. No last minute changes, strict time frame. It's a dynamic document, just like the loan estimate. It's not hard-coded like the HUD-1 is now, and we'll look at that. But the creditors, here's the key thing, the creditors, the lenders, they have to decide who's going to be responsible for creating and delivering this document. Again, all the enforcement is on their shoulders. Back in April of 2012, I had to check my date, the CFPB sent out a bulletin. It was basically an open letter to lenders everywhere. And they said, hi, we're the new sheriff in town. In the settlement service process, we recognize the value in using third-party settlement service providers. Lenders, you can't do it all. It doesn't make sense for you to do it all. So you use other service providers like title. We've got the realtors. We've got the appraisers. We've got, you name it, whatever services contribute. We recognize the value in that, but lenders, you're responsible. If you're using third-party settlement service providers, that's great, but you're responsible for any harm that comes to the consumer as a result of any of their actions as well as yours. So the creditors, it's all on their shoulders. I've said it before. I just want to make that point very clear. So the creditors have to decide who's responsible for creating and delivering this closing disclosure form. It could be the creditor, it could be the closer, the title company. But we have to track delivery. We have to track some very specific time frames. We also have to track accuracy. So why would one party or the other handle the closing disclosure? The onus is on the lender, but maybe the title company is better positioned to collect all the information. Lenders have to decide. The major national lenders, the real big guys, have said, we're going to do it ourselves. They're going to do it. They're going to do it about 10 days prior to closing. A lot of the regional and local lenders that I've talked to are saying, we can't take that on. Title company's going to do it. Doesn't matter which way it's done, just as long as you have that established in advance of August 1st. How will the new process work? How will we work with changes? Who has to give what approvals? And we'll look at how this is going to be a little bit of an issue from time to time. So, the time frames. The consumer has 3 business days to review the document. It has to be in the consumer's hands 3 business days before consummation. Unlike the loan estimate, a business day has nothing to do with the lender's business operations. Doesn't matter if they're open or closed. A business day is Monday through Saturday. The only days that don't count are Sundays and the 10 federal holidays. Otherwise, the rest of the days count as a business day. 3 business days, and not 72 hours, 3 business days. So we're not, I gave it to the customer today at noon, so we can't close until noon 3 days from now. That doesn't, they're not paring it down to that tight of a restriction. 3 business days in advance of consummation. Most times, consummation is when you're going to sign all the loan documents and you're going to handle the disbursement. But there are times when the consumer signs the note before they sign the mortgage. That comes after the fact. Consummation for this purpose is the day the consumer becomes legally obligated to repay the debt. That's the day they sign the note. So if they sign the note before you sign the mortgage, this closing disclosure has to be in their hands 3 business days prior to them signing the note. So it's a little trick there. Keep that in mind. So here's some CFPB math for us to look at. Here they go again. That silly CFPB. What have they done? Did you know 3 days really equals 6 days? They tell us 3 business days. That very quickly, as you'll see in the next slide, turns into 6 or 7 days or even more. Major national lenders have said, we're getting this thing out 10 business days prior to close. Here's a chart. This is the American Land Title Association. They've put together this chart. And Zeb and Kelly may make this available on the Watermark website, perhaps. It's at alta.org, alta.org. This is a great reference tool because it shows us exactly what we have to deal with. If the closing day is Monday, the disclosures are due a minimum of 3 business days in advance, which means they have to be in the consumer's hands the preceding Thursday. Now let's talk about delivery methods. Delivery is assumed to be immediate upon hand delivery from the lender to, or the title company, whoever's creating the disclosure, hand delivery to the consumer. If Mr. and Mrs. Smith are the borrowers on the loan, hand delivery to Mr. Smith is not hand delivery to Mrs. Smith. It's hand delivery to each and every borrower. Or we can deliver it by a courier with a signed receipt. Delivery by courier, DHL, FedEx, whomever, doesn't mean one package to the Smith family. It means one package to Mr. Smith and one package to Mrs. Smith. And in fact, Mr. Smith has to sign for his, Mrs. Smith has to sign for hers. Not the babysitter, not the kid who answers the door, not the neighbor or aunt and uncle who are visiting, but those parties themselves. A little bit of a trick to that. The other alternative for immediate delivery is an email. Now the consumer has to give prior approval to receive these documents via email, and that oftentimes works. I know there are talked to many lenders whose delivery systems will say when the email comes in, the consumer, before they even open the email, has to say, yes, I acknowledge or I authorize delivery of these documents via email to me. They authorize that. Maybe they do it at the time of loan application. They sign a form saying, yes, I authorize delivery to me via email. And then when they open it, there has to be a return receipt. So we have to know that they've opened the email. We don't have to know if they've read the disclosure. We don't have to know that they've understood it. All we have to know is that they've opened an email to which the disclosure was attached. But not until that read receipt comes through can we start the clock counting. Just like the delivery, other delivery methods, the email, one has to go to Mr. Smith, one has to go to Mrs. Smith. We can't deliver 2 of them to smithfamily@aol.com. And many households have that single common household account. We need an individual email delivery to each and every consumer. So lenders, realtors, make sure you're having those communications, make sure you're collecting individual communication methods for each and every borrower on that note, on that mortgage. Otherwise, we have to add 3 days to this if we're delivering it any other way. That other delivery method being the U.S. mail. I love how we blindly trust that when we put a letter in the U.S. mail that it's going to get there, you know. But nope, we figure it'll take 3 days. When you drop in the U.S. mail, it'll take 3 days to get to the consumer. And then you have to wait 3 business days from there to go ahead and close. And when you add that up, there's going to be a Sunday in there every time. So now we're up to a week. So if you want to close next Monday, the mail disclosures have to go out the preceding Monday. Or if you email it to the consumer and you do not get that read receipt, then we presume that it's going to take them 3 business days before they see it, and then they've got the 3 business day wait period. So we're upwards of a week. A lot of lenders are saying we're going to mail it out. We're going to send one in the mail to Mr. Smith, one to Mrs. Smith. We're going to do it 10 days before closing. So that means the numbers have to be final. This is the final closing disclosure 10 days before closing. So instead of shuffling at the closing table, we need all this information collected well in advance. We need to be ready for this. It's going to put a lot of pressure on the lenders. It's going to put a lot of pressure on the rest of us. Realtors, you got to get your commissions in. If you have any admin fees, if you've paid any invoices on behalf of the borrower and you want to collect that money as part of that settlement process, you need to get those invoices into the lender well in advance or into the title company well in advance, depending on who's going to put this together and deliver it. Okay. As with the loan estimate, the closing disclosure can be revised and resent, and in fact it has to be, and we have an additional 3-day review period in very limited circumstances. And I'm going to go out of order off my slide. The first circumstance being that the lender, somehow they've taken the loan application, we've gotten down toward closing, and they go, oh wait, I'm going to add a prepayment penalty. Not going to happen. But that is one of the circumstances. If the consumer changes the loan product, I said earlier, it was originally at 15, they want to change to 30 because they don't like the bigger payment. Has to redisclose. We have to wait the 3 business days. Now, if they make that change, like I said before, the loan estimate also has to be revised, and now suddenly we've delayed the whole closing by 7 days minimum. And here's the other one, inaccurate APR. For regular loans with a regular monthly payment, paid on a regular, consistent basis, 1/8 of 1% margin, plus or minus, is what is permitted. This is why any fees that are going to be financed cannot be, on the loan estimate, can't be padded excessively. There's a narrow band, plus or minus 1/8, that the lender has to stay in for truth in lending purposes. So if the APR is changed or it's off, new closing disclosure, 3 more days, wait all over again. So think about that when we're getting down to closing. If we're going to submit any fees or the consumer is going to be subject to any fees that could affect the APR, we may very well have them miss a very crucial deadline, and we cannot bend the rules. No matter what the excuse is, we can't bend the rules. $1 million a day, knowing violation penalty, okay? There is one very narrow exclusion to that. If the consumer is facing a bona fide financial emergency, then they can waive the right, the 3-day right, in writing. Bona fide financial emergency is one thing. The bona fide financial emergency is when the consumer is about to be evicted, be out in the cold because their home has been foreclosed, they're getting booted out of their house. That is it. No other thing is a financial emergency. Rate lock expiring, I got to pay off this other debt, my credit card's due and I need my refi. That's not a financial emergency. And in fact, many lenders have already commented, in their world there is no such thing as a financial emergency. They don't want to take the risk. So we're stuck with these things. These are very tight, very specific timelines. Other circumstances will commonly arise at closing. It's not going to require a redisclosure. We don't have to jump through the timeline hoop, but it is going to possibly delay the closing. There are things that we shuffle at the closing table that don't affect the loan amount, don't affect the fees, but could delay things. Case in point being a builder shows up at closing with a new invoice that was unanticipated. Maybe the consumer on a new construction, they're going to have Corian countertops, they wanted to upgrade to granite, and it's going to cost them another $5,000. And the builder shows up at closing, says, yeah, well, forgot about this. Here's an invoice, additional $5,000. All right, if we increase the loan amount by $5,000, we have a problem. Now we're back to a new loan estimate, new closing disclosure, bump the closing. If, however, the consumer says, that's fine, I'm just going to pay him out of pocket, that's okay. But because that is a charge related directly to the transaction, it has to be disclosed on the closing disclosure. There's no off-record matters. We can say POC, but we have to put it on the document. Okay, we can't skip this stuff. We can't pretend like we're blind and deaf to these things. And that means that the closing disclosure has to be reworked. Right now, today on the HUD-1, the closer just goes, shuffles it around. In most cases, the lender says, if it's not a significant change, just do it. They don't care. They run back to the office, they shuffle it around, print a new one, and you proceed. No big deal. Going forward, however, because of how serious they are about fines and balancing everything out, the tolerances, any change is most likely going to have to be approved by the lender, no matter how insignificant. And so it's going to have to go from the title company to the loan officer to underwriting to compliance, trickle all the way back through those steps back to the closing table. It could cause some real headaches at the closing table. Just be aware of this. If we're working with any parties, those of us who have to submit invoices or anyone else with whom the consumer is working, with whom we have a relationship or who we can contact, make sure we are making this very clear. We need this stuff way in advance. Builders are the big one that we're going to have to work through this with. Owner's title insurance, again, I explained it on the loan estimate. I won't go through it again, but it is going to appear the same way, out of whack. The only thing that's hard-coded now on these documents is the fact that owner's title insurance is identified as optional, which I find funny, take a little offense to it because I'm a title insurer. It certainly is optional, but that's the only hard-coded thing on the forms. And the CFPB has said, hey, I'm not going to sell your insurance product for you. You have to sell it. Funny because property insurance and flood insurance and other insurances, nothing else is identified as optional, but this is. The consumer has no protection under the loan policy, and I advise don't inadvertently become an insurer by advising against an owner's title policy. If the consumer asks you, the realtor's in the room, the consumer asks you, should I buy an owner's policy? You have a fiduciary duty to that consumer. If you tell them no, don't buy it, and they in fact end up with a title claim, they may very well have grounds to come back and sue you for a breach of fiduciary duty. So be careful about that. They need to make their own decision, and I'll leave it at that. Here's a closing disclosure. Looks a lot like the loan estimate. Again, beautifully organized. First page, all the key information. One thing I'm going to point out up at the top, a lot of you probably can't see this, that says closing date, not consummation date, closing date. That's interesting. What they really mean is consummation date. That's when is the note signed. Then from there we go through the loan terms, loan amount, rate, P&I, the escrow calculations, payment calculations, closing costs, and cash to close. Nice and simple. Page 2 kind of looks like our current HUD. It's not double column, it's a single column going right down. All of the details, all of the individual fees that you see there are not hard-coded. Again, that is whatever we want to call them. And they are arranged for borrower's clarity in alphabetical order. The vertical columns to the right. The first column are the borrower pays at closing and before closing. The second column are seller paid contributions at closing, before closing. Third column are those charges paid for by others as part of the transaction. You will note there is no distinct seller side here like we've become accustomed to. It's because it's been peeled out. The sellers are going to close on a different document. We'll get to that momentarily. So this is just arranged much like the loan estimate. In each category, they total, line items total up to the top of the categories total down to the bottom of the page. And we'll skip this. Now this is the third page of the closing disclosure. Up at the top, here is the variance box. So it goes through categorically, what did the loan estimate say the loan would cost? What is the actual final cost here on the closing disclosure? And it asks the question, did it change? Simple yes, no. If it changed, we have to fill out an explanation. Yes, it changed. The appraisal fee came in at $700. We estimated $500. Lender credit $200 to make up for it. That's how we do it. Bottom 2/3 of this page looks much like our HUD-1 does today, the first page of the HUD-1. It's the general summary of the transaction. Where's the money coming from? Where's it going? You'll notice, or maybe you can't because it's small, but all of a sudden the alphabetical order goes away because if I'm in section L, paid on behalf of borrower closing, goes from deposit to loan amount to existing loan assumed or taken subject to. If I'm the consumer, I don't know what just happened. It was alphabetical, it's not alphabetical, I don't know. It's funny though, they give us this very strict requirement, strictly alphabetical, and then we get to this page and the rules are out the window. Closing disclosure, page 4, very simply just some of the key loan terms. Is the loan assumable? Does it have a demand feature? What are the late payment charges? Is it a negative AM loan? Partial payments, are those permitted? What are the escrow calculations? And then we get to page 5. It's the loan summary again in the upper left, the total of payments, the overall finance charge, the total amount financed, APR and tip. Other disclosures, liability after foreclosure, lenders required to provide the appraisal, and then at the bottom, contact information. So all the parties to the transaction, their contact information's there. And here's where the CFPB doesn't follow their own advice, because in that box, the first column is lender, not creditor. Then it moves on mortgage broker, real estate broker, buyer, real estate broker, seller, and then settlement agent, not consummation agent. And finally, the consumer is going to sign this form. And the signature box says, by signing, you are only confirming that you have received this form. You do not have to accept this loan because you have signed or received the form. This doesn't acknowledge that they received the form 3 business days in advance. They don't date it 3 business days in advance. They date it when they're at the settlement, at the consummation table. It's like the marital bed. It's weird. And all they do is they say, yes, I've received it at this point as part of the transaction. That's it. Doesn't obligate them in any way. The selling closing disclosure, I told you, we're going to peel it away now. The seller, per the CFPB rules, seller's provided with a closing disclosure by the settlement agent, not the lender. And it's not optional. It's by the settlement agent, escrow company or attorney agent, the closer, at consummation. The seller doesn't get a 3-day prior review. In fact, we don't care about them. We're just going to surprise them at the table. Hey, guess what? Here's what's happening. Hope you like it. A separate form for seller purposes only may be created and, in fact, should be used. The CFPB has provided us with a sample form. We can use the CFPB's form. We can use the current HUD-1. We can use the old HUD-1. We can put together a spreadsheet, use a spreadsheet. We can write it on a napkin. We don't care. It's the seller. They don't matter. So there's not really much. There's really not much protection or really any guidance at all on the seller side. Why have we stripped away the seller side from the buyer side now? Bifurcated to avoid inadvertent disclosure of non-public personal information. Gramm-Leach-Bliley Act of 1999 puts restrictions in place of non-public information. We've read the headlines, all the information getting out, the Target and other companies, their security breaches and data breaches. This is a serious thing. We've had the law since 1999, but we finally awakened to it, and we're taking these things seriously. So we don't want to inadvertently disclose personal information of the buyer to the seller and vice versa. So we strip them apart. Another advantage, settlement agent can control preparation of the seller side without having to involve the lender, without having to jump through those hoops or make the lender jump through those hoops, especially if it's a change that doesn't affect the buyer's side of the transaction. The builder comes in with a $5,000 invoice. The consumer says, I don't have $5,000 cash, I can't pay it. We're saying, well, that's it. We're going to have to bump, we're going to have to reapply, change the loan amount, and the builder says, you know what, I'm just going to eat it. That's fine, I'll discount it, I'll eat it, I'll take the hit. Perfect. Now we don't have to go redo everything. Lights out, huh? Yeah. Now we don't have to go back and revise the buyer side. We can just fix the seller side at the closing table and move on. It also allows proper disclosure of the title premium on the seller's side, so if the seller's contributing, we can show them what they're actually contributing to and not the funny CFPB math. So here we see the seller's closing disclosure sample the CFPB gave us, a clean, straightforward document. I'm not even going to waste time on it. We're coming to the end. What are the lessons? Collaboration is key. Communication among all parties is critical. We have to make timely and accurate disclosures. All of us have to contribute to this. We all have to feed information that we are privy to through to the lender, through the title company, and among all of us. The CFPB is serious about enforcement. $1 million a day, no bending the rules. If you walk out of here with 2 lessons, one of them I hope is something's changing, I think. And the other one I hope will be $1 million a day if we break or bend the rules. No more bending the rules. And then a little twist, ECOA, Equal Credit Opportunity Act. That says that the appraisal has to be delivered to the consumer upon the earliest of receipt or 3 days prior to closing. This is the only waivable provision in all of these laws here. The consumer can waive that right. And in fact, many times the lender will have them waive that in advance in writing. So what do we do now? Lenders, determine who's going to produce and deliver the closing disclosure. Who's responsible for this? How are we going to track it? How are we going to track those delivery timelines and know that it got to where it needs to be? Lenders need to know the timeline, set clear expectations for everybody else involved. They're the ones driving the bus on this. Don't cut time frames short due to business pressures. I've said it many times. I'm not going to repeat it in any detail. And finally, Who's going to be on that service provider list that has to be handed out with a loan estimate? Because again, if there's a provider on that provider list and the consumer does choose to use that provider's services, your quote has to be within 10%. And that's an aggregate quote for the category, not per line item, not per provider, 10% overall. Realtors, what do? Disclose your fees early. Make sure you've got all that information into the lender, into the title company 10 plus days prior to closing. Again, the big national lenders, the BOAs, Wells, Chase, they've all said they're going to put the closing disclosure together 10 days in advance. If you don't get your fees in 10 days in advance, tough. You're done. You're out of luck. They're not going to revise it. Is a title company on the lender's approved list? Lenders are responsible for anything that goes wrong. We want to make sure everybody we're working with is acceptable to the lender. Of course, the borrower has the right to choose any title company they want. The lender can't say, no, we can't close there. But we do need to make sure that the lender has communication with them and that they're prepared to work together. Know the new timelines. Respond quickly to questions. Make sure your client's aware of how critical early and clear communication is. Make sure that you're hammering it into their head. I need to know if things change. I need to know right away. I know you tell them that already. And they don't listen. Oh, I changed jobs 3 times since I applied. What's the big deal? We need to be very clear on this because it really, if they don't share information, that only works to their detriment. You know, we have to go through more work. We have to change our procedures, but really it's to their detriment at the end of the day. This is the one where people do want to throw things at me. This is not me talking. This is the industry generally chatter. Amend walkthrough times with a first final walkthrough, not the final. First final as early as 10 days prior to closing. Tough to do. Chances are the seller's not going to be all packed up and out of the house. But if there are surprises, we want to know of the surprises as early as possible. We don't want to be making those adjustments at the closing table to the extent that that might impact the buyer's side. If it impacts the seller's side only, not such a big deal. But maybe you find something that will negatively impact the value of the home. Now suddenly we have to go back through the loan process again, the loan estimate, the closing disclosure, and the time frames. So we want to know those things as soon as possible. It's probably not going to look any different, but it might. And finally, be ready to assist. I mentioned about the HOAs. Be ready to kick in wherever you might be able to lend some assistance to try to hurry some of the information through the necessary channels. So that's the end of the presentation. I really appreciate all of you joining us today. I hope. Okay. Welcome back. Now we're going to do the Q&A period. So I am going to welcome any questions that you might have. If you ask me a question, I'm going to repeat it for the privilege of the people who will be watching this remotely on the webinar. My first question is, by a show of hands, who's going to quit on July 31st of this year? Yeah. If you've ever thought about maybe going into small engine repair, now might be the time to do it. All right. Does anyone have any questions? Show of hands. I'll be glad to answer or try to answer any questions, concerns you might have, any discussion. Yes, thank you.
I know it goes live on the packets first, but if they're going to be some sort of like transition period where there's kind of like a grace period for everybody to get up to speed.
The question is whether or not after the new rule goes into effect, is implemented on August 1st of this year, whether or not there will be a grace period or an implementation period thereafter, and the answer is no. Various industry groups have asked the CFPB if they will restrain enforcement because, unlike in 2010, we can't start to practice with this sooner on consumers. We can't use these forms until after August 1st. We can only use them on qualifying transactions. Now, that doesn't mean that we can't practice. So as between lenders and title companies and brokers and whomever wants to get in on this, probably this will be directed by the lenders, we can practice behind the scenes, but we can't actually use these forms and approach consumers with them until after August 1st. And the CFPB has said, nope, no implementation time frame. We don't let you practice, and in fact, if you screw up, we're going to enforce it, even though you're not totally comfortable with it. So it will be probably a little bit of a bumpy road initially because we are all going to have to adjust to a very different way of doing things. I mean, you've seen it, it's a sea change. And so that is something I think that we're all going to have to somewhat apologetically address with our clients. Hey, things could be a little off here, and hopefully we can work through it smoothly, but there will be hitches in the road, and no, we don't get time to really officially practice. Oh, thank you.
One of those exemptions was 5 a year. If you do less than 5-year loans a year, are your first 5 free then?
That, I love that. I have not been asked this question before. The question was mentioned that one of the exemptions was for creditors who do 5 or fewer loans per year, that they're not under the obligations in this law. And so the question was, does that mean that we get 5 free ones? The first 5 we don't have to use this on? No, I'm afraid not. We look at how many do you do in a year. If you've done more than 5, then all 5 have to comply. Yeah, or all 6 in that case, 6 plus. Yeah, good question, sir.
Do you think it might make sense for buyers to come in and do like a dry closing or a pre-sign or something like that 5 or 10 days before?
The question is whether or not it might make sense to have a buyer come in and do a pre-sign or a dry closing 5 to 10 days before the actual closing. Here's the thing. If they're not signing the note that day, the rule applies to consummation being the day that they sign the note. If they're not signing the note that day, then that may make sense. You can send it out, have them come in, do that portion of the closing, make sure there are no bumps in the road. But what are we ultimately doing? I don't think that changes a whole lot. What we're doing is we're still building in a bigger time frame. We're still extending the time. Now, in that case, if we do have issues, if any surprises come up, then at least we're not quite so crunched on potentially the rate lock expiring or something like that. But here it is. It's creating ultimately more work, more hassle, multiple times potentially at the closing table. But that is a possible answer to this. Yeah, good suggestion. Yes, sir.
So scenario, let's say you did that 10-day prior final walkthrough, and you're doing the final walkthrough. Final, and the seller damaged a chandelier on their move out.
Yeah.
They want to credit the buyer $100 because they're never going to get that chandelier in time to do it before closing. In that situation, is there something that could be credited or that could be triggered there for new time frames?
The question set up a scenario whereby the buyer is walking through the house doing their final inspection, or maybe their final, however many we end up having to do, and they discover there's damage to the property. And so rather than fix it, the seller has offered a seller credit back to the buyer. What effect will that ultimately have? Will that require redisclosure? And the answer to that in most cases is going to be no. Because that is the redisclosure for the closing disclosure, or even going back to the beginning and redoing the loan estimate. That's if a key loan term changes. If we're changing the amount financed, the loan product, some of the fees. But this is a seller credit. And we had a little conversation during the break about that. Someone else asked a similar question. And this does not play into the APR calculations, so that's not going to violate the pretty narrow truth in lending APR parameters. So no, that's just an additional credit. What that might do is it might delay the closing because we do have to juggle the closing disclosure form. So that might take time. Again, to go back to the lender, loan officer, underwriting, compliance, make sure it's okay, feed it back through. It's going to be a delay at the table. But no, I don't foresee something like that. If the seller's giving that credit, I don't foresee that having to go through the 3-day or the 7-day wait period again. No, good question. Thank you. Yes, ma'am.
So if an extra recording fee pops up, let's say a name affidavit that wasn't originally disclosed, can the lender add that extra $46? And let's say they're 2 days, so let's say they reviewed the HUD, we're going to add $46. It's okay to do that as long as that's within the 10% tolerance.
The question.
Or the lender then could show 46 and the lender here for 46.
The question had to do with, the example was recording fees. If we get to the closing and we discover there's an additional recording fee that we weren't aware of, whether or not we can make that adjustment. And so the loan estimate disclosure of recording fees states that must fall within 10% of what is disclosed on the loan estimate. The file number must be within 10%. If the recording fee, the additional recording fee here in the state of Minnesota, one more document at $46, doesn't bump the APR, which it's not going to. If it doesn't change the loan amount, if it doesn't violate the 10% aggregate categorical restriction, then you can actually just put it in there, charge it straight through to the buyer, and that's not going to impact anything. If it does impact something, then the lender has to decide whether or not they're just going to absorb that additional fee, or not. Or otherwise, we may have to, I think it depends. To be able to really fully answer the question, depends on whether or not the recording fee was anticipated. Was there a surprise? Is there new information at closing that allows the lender to go back, redisclose, do the new loan estimate, new closing disclosure? We're adding in a lot of time here. So when we're talking about a recording fee and it's $46, it'll probably be within the tolerance or the variance amount. I got to get my language right, the 10%. But if it's something much bigger, and then maybe it would violate the 10%, maybe it's going to require redisclosures, and maybe the creditor just says, I'm going to absorb this and let's just move on. And maybe if a party to the transaction gave bad information or misinformation or misunderstood something, hopefully that party would be kind enough to step up and say, I made the error, that's my fault, I will absorb that mistake. The lender can't force anyone else to absorb costs, but certainly any one of us can do so freely of our own will. So yeah, it just, it's very fact specific whether or not we have to do that. But if it's within the variance, then we can actually close out of the variance or within the variance window, but not have the exact matchup. So
same thing with like association dues, because sometimes the association wants the first month's dues up front. And let's say that wasn't anticipated, so the buyer's cash to close increasing by a couple $100, but that can happen at closing table, right?
the question was whether or not if you have association dues where the first month has to be prepaid, and we weren't anticipating that, whether or not when we get to closing, do we have to go back through and do all the redisclosures on that one? And the answer to that, no, we don't have to jump back through the hoops. The buyer does have to bring additional cash to close to cover that. We have to adjust the closing disclosure. But no, that's not in one of the variance or tolerance categories, so that can change. It's free to change because it's one of those fees that's of the nature where we don't know what it's going to be at the end of the day. The same thing goes for property insurance, because property insurance, maybe they're just insuring the home, or maybe they're doing a bundle with a car and another home, and who knows what that bill is going to look like. The lender needs to make their best effort to estimate that, whatever's reasonable for the property, for the transaction, for the locale, but that doesn't have to be precise. The HOA fees don't have to be precise either. Yes?
But if the HOA fees change, is it 3 more business days on the change in the final disclosure of the closing? Because that's changed.
Right. The question is whether or not when the HOA fees do actually change, that's going to change the numbers on the closing disclosure, and because numbers have changed on the closing disclosure, will that then necessitate another 3-day wait on the new closing disclosure? Did I get that accurate?
Yes.
Okay, I got that accurate. I'm going to jump ahead here. Redisclosure of the closing disclosure form is only necessary if there's a prepayment penalty added or a change in loan product. That's not certainly this case, or the APR has changed, whether it's gone up or down more than 1/8 of a point from the initial loan estimate form. In this case, with an HOA fee changing, an HOA fee is now part of the APR calculation, so no, it will not require the additional 3-day wait. It will require that the form be juggled, but you can still close the same day on that, assuming that everybody can get together and generate the new form. It's a good question, thank you. Does anybody else have any questions? Yes, thank you.
Was it clarified in the reg? You said the APR goes up or down. Was it clarified in there, up or down? Because back when they did Russell's point, it wasn't, so it was up to interpretation.
The question is whether or not, when we're talking about the APR variance, whether or not they clarified up or down, or is it only if it increases? It's either one. It's up and down. Plus or minus 1/8 of a point on regular loans, plus or minus 1/4 on irregular loans. So what they're looking for is they really want that dependability. They want the consumer to know pretty clearly what product they're getting and what that's going to look like at the end of the day, so that those disclosures need to be made clearly up front. Estimates need to be relatively accurate, as close to possible as accurate up front. Certainly, the APR calculation is mainly things that the lender is going to know about right away up front anyway. So there's really no excuse for that to change too much. Certainly, you'll get changed circumstances during the interim period, and that's why it's important that everybody communicate back with the lender. So the lender, anytime you get new information, that lender has to feed back a corrected loan estimate. So there could be many loan estimates going out in the course of a single loan transaction as the target changes. And on that topic, There's another nice reference, and it's a TILA RESPA integration disclosure timeline example. This is issued back in September 2014, and it's a scenario that the CFPB walks us through. It's on the CFPB website, and I'll repeat it again. TILA RESPA integration disclosure timeline example. It's the timeline example form, and it walks you through all kinds of little hitches in the process, and it even gives us calendar pages where it's showing us application on this date, loan estimate on this date, change circumstances here. It walks you through several months of a loan transaction with all kinds of different contingencies. It's a nice, quick reference as well, so you can see it depicted graphically and see some of the hoops the lender has to jump through to keep up with changes. Anyone else have any questions? Going once? Going twice? All right. Good. Well, thank you again. We really appreciate you joining us. Thanks for your time.
Calculator that is available for everybody on our website at wmtitle.com. And there's a mobile app-friendly version that you can download. It's a piece of cake. And talk to any one of your Watermark closers. They can text it over to you. You click on the link. You select Add to My Homepage on your iPhone or your Droid, and it creates a little app right on your iPhone. It's a really great function here. And so you can be mobile and come up with, it has a number of different options in it. It has you can work up seller net sheets, good faith estimates, principal, interest, taxes, and insurance calculators is on there. It's all kind of a one-stop shop for our industry. I'll show you an example of it here. So if you go to Watermark Title's homepage and you click on Fee Calculator, it brings you to this page here. You create a username and a password, like we have to do all the time now. And let me just enter password. Should load up really quickly what the app looks like, depending on our connectivity speed here. But one of the important features of this tool in the mobile-friendly version is we have to be exact in these numbers now, right? And we can't have much tolerance, if any. So it's very important that we have some accuracy in what we're doing. So it is loading. Maybe. There we go. Okay, so if you look in the upper left here, we have a buyer's estimate sheet, and you can work it up. State of Minnesota, Hennepin County, for example. Put in your sales price, and it automatically puts in a 20% down payment. You can change your default percentage that's in there, and it automatically calculates the loan amount. Input your interest rate, term 30 years, and you can edit other items in here really easily. Property taxes, home insurance, etc. Generate an estimate. Shows your principal, interest, taxes, and insurance right there. And, I'm sorry, principal and interest right there. And if I input taxes and insurance in the previous screen, it'll calculate that for you as well. Breakdown of what's due at closing. You can get a printer-friendly version, so it'll create a PDF for you. You can save this estimate in your profile once it's set up. So in other words, you hit save, and right there you can go and look at your previously saved documents that you have. You can send it via email to your clients. Just type their email address in here. You can generate a HUD. You can transfer it to a net sheet. It's very slick. There's a lot of great options here. I think we've looked at the entire market for this feature, and it's great for lenders and realtors alike. It's the best tool we could find. In here also, seller's net sheets. Again, Minnesota, Hennepin County. You can put all your data in here, and you can add additional items to this as well. And we've got the company to actually be itemizing a few things that are Minnesota specific as well. They're going to be adding to this calculator. We've also got a title quote, which is very important for you, again, lenders and realtors, so that you can give your clients accurate numbers and there's no really big significant changes at the end. Again, example, pick Hennepin County. Purchase with financing, you can do cash or refinancing. Property sales price. Loan amount. Generate a quote. And it'll show you a great breakdown, seller and buyer charges. And you can view it in GFE format, good faith estimate format. Again, printer-friendly version in a PDF. You can save the quote. You can send it to your clients via email. Transfer to a seller's net sheet. Generate a HUD. Okay? And of course, whoever closer it is that you sign up with Their contact information is right here. You can email this to yourself and it shows, or your clients, and it shows your contact information too, because once you actually sign up for this calculator, you have your own profile. And it will have all your contact information that you send to your clients. It's great. So, for example, you get your name in here, your email address, contact information. You can put your photo on here too. Louis Skolnick, sorry, no. So this is great for all clients out there. And if you want to download this to your phone, again, reach out to us if you can't figure it out. We'd be happy to show you. We helped a lender put it on their iPhone yesterday. It probably took all of 40 seconds. So if you want to help us load that on your phone before you leave, we'd be happy to do it so we can knock it out very quickly. But also, you can go right to our website, and this is on our website as well. So great feature for all of you, and we hope that you use it. It's there for you, and it's a great value add too. So thanks for listening.